when you are investigating the so-called big fish, it's not as easy as a police officer receiving a bribe, which is very blatant, which you can see. You can't trap the big fish with treated money. They'll not receive it here. They'll receive it in a numbered bank account in Switzerland. They'll receive it in an account that does not bear their name in different parts of the country, and therefore the process of investigation takes a little longer. It is true that there are big fish who are in court. If you look at the golden bag, we have cases against permanent secretaries, but the cases have been parked. The big fish also hire the best lawyers in town. They have gone to court, they have gotten orders, and the cases have stalled. So there is a sense in which there is an abuse of the legal process. So going forward, we must have a judiciary that is bold enough to deal with these individuals.
Well, it's definitely not easy to net the big fish. Those are words of Philo Lumumba when he was the chair of the now defunct KACC, the Kenya Anti-Corruption Commission. Kevin Mugeni, it's not easy to deal with big fish, and I mean the big shorts definitely have an intricate connection, not just in the judiciary, but other systems in the criminal justice system. But I mean, it's not easy convicting white-collar crimes. This comes with its own difficulties. Following the money trail is easier said than done, as we've constantly witnessed time and time again. And the defense team that is brought ahead by these people who are enabled in society is also a deterrence towards the swift dispensation of justice. What details arise in getting a proper conviction? When we're looking at economic crimes, what exactly are we talking about? Because they seem to be lagging, time and time and time again. But what exactly are we looking at?
You said right now what we're doing as, when dealing with the questions of economic crimes, we are actually doing the postmortem. And I think what needs to be done, we need to look at the symptoms and treat them before we go to the questions of the postmortem. Economic crimes, take place in boardrooms, in offices, and everywhere else. And most of the time, the documentation is massive. There's so much that needs to be done. And by the time the investigators catch up with these persons, most of the documentation has already been interfered with. So that by the time this matter is reaching court, there is so much that needs to have been done. They need to have enough forensic evidence to ensure that there is enough evidence that can sustain a conviction within our legal system. So it is not just to say that the big fish get away with it. It is because it is not easy prosecuting such kind of cases. And it is not that they're getting away with it. It is not as simple as taking up a forged document to a bank where it is an open and shut case. This involves a lot of intricate issues that are handled over a long period of time. And by the time the matter reaches court and these persons are able to get attorneys who can be able to go through this with a toothpick and ensure that they can destroy the evidence that is presented by the prosecution. And what in essential cases happens is that the prosecution should not, in these cases, hurry or rush to present these cases in court. They should have a watertight case, properly investigated before they rush it to court, so that by the time they present it before the court, they have enough evidence to convict. And I think the issue we get, where we go wrong, is that we don't take enough time to ensure that proper investigations has been undertaken and evidence collected. We should have one case, not necessarily many cases. We can just have one case where proper investigation is done, and it forms as a deterrent for subsequent issues that happen. And I think that is where we need to concentrate on when you're fighting questions of corruption and economic crimes. Not necessarily that you need to have as many as possible in court. Of course, as the DPP said, a big fish is able to hire enough lawyers to ensure that all the avenues available under the law are undertaken to protect himself. Not that they are doing anything outside the law. It is what is allowed, but the lawyers have to ensure that all that requires to be done is done, which is not normally available to somebody who does not have a good legal representation.
All right, Kevin, you've brought up that issue about lawyers, and I mean, justice delayed is justice denied. We know of this, but there seems to be backlog of cases year after year in the courts. And Maraga recently pointed an accusing finger at, not just that they shouldn't just blame the judiciary. The police, the witnesses, and the prosecution as well should also receive part of the blame. But I dare ask, lawyers causing a stalemate of cases through adjournment of cases, obtaining orders to slow down the case. We've had this time and time again. Yes, it is within the legal constraints, but surely is this double standards? What do you think about this?
I don't think that statement is logically correct, because adjournments are not caused by lawyers or lawyers alone, because we've got so many factors that cause adjournment. Even the court itself, the court can be indisposed, the prosecutor can be involved in a training. There are so many reasons where matters are adjourned, witnesses are not there. So it's not necessarily that we're having lawyers undertaking this process of adjournment. Cases are adjourned on reasons that are presented to the court, and there's always a reasonable ground for that. So I don't think that we need to wholeheartedly come out and say lawyers are causing this adjournment. There are reasons. The reasons for that. But see, one thing that we need to do, and we are trying to do that as ICJ, we need to do a corruption watch series where we can ensure that data that on all these cases are going on is collected and shared with the public, because this is collected on a daily basis. There is they call the daily court return template that are filled by the judicial officers. This can be shared, and you'll notice that the cases adjournment are not caused by the lawyers.
All right, Mugeni, moving on, in terms of double standard in bail terms and the recent, debacle of paying in installments, the case involving Babu Wino and the gun drama he had earlier on. Talk to us about this. Is this possible? And I mean, is it double standard right there? Are there guidelines when it comes to paying of bond and bail? Talk to us about it.
There are bail and bond policy guidelines which were set out way back by 2015 by the former Chief Justice, and these have been shared out. We came in as a committee to come up and monitor the implementation of those policy guidelines, and we have actually come up with a bill that we are going to present to. We hope the Chief Justice will present to Parliament, and with the help of the other sector players in the National Council on Administrative Justice, it can be properly set out to be passed. But having said that, what happened in terms of giving bail in installments, you can actually call it installment, it is not something that has been practiced before. And even going to pay the victims of this particular criminal act, I think maybe we are writing this process. But as I said, discretion is given to the judicial officer to come up with certain terms as they believe that could be or how it should happen. And because now we have come up with this implementation process and the proper provisions that will be encompassed in the law, I think now we look forward to having a better system. But I will say this. We have been having the implementation of bail across the board in the country has been so disparate. They have been so difficult, to monitor and ensure there is uniformity. And because of the way it has been applied over the years, some persons you go charged with the same offense and you'll be released at a cash bail of 5,000 shillings. In another court, you'll go and you'll be given $1 million. So it has not been uniform. And it's been very difficult to ensure that this happens. But the question is, how are you going to train these judicial officers so that they can understand? You talked about Article 49, because that is a right which is there in the Constitution. Then there is a rider that you see, unless there are compelling reasons, you cannot be released on bail. So the question that has been going on is, how do you balance the right under the Constitution, which allows you to be given bail, and that caution that has been also set in the Constitution, that there should be certain compelling reasons why you should not be released on bail. So these are the conversations we have had. We have had it over the years, and we came up with reasons of setting out what are compelling reasons from circumstance to circumstance. They're not ever the same, but these have been shared out. And we came up with two major things, apart from the bail and bond bill. We also came up with the digest on the bail and bond, which has been applied by the courts over the years. There are two, Volume 1 and Volume 2, which is now available at the Kenya law. They're having those books. They'll be shared out very soon. They can be able to be bought. And those ones set up very clear determination on what compelling reasons are and which ways this can be applied to ensure that there is some kind of uniformity and the public can ensure that there is no underhand in applying these terms across board. And I hope that soon enough, when all these things are set clear, like the DPP said, yes, justice has to be done by following certain laid out guidelines which are uniform and which are in a way determinable, and somebody can be able to know in such a situation this is what happens, and that is what we expect to happen in the future.
All right, Kevin Mugeni, very critical issues right there in terms of the balance as well. Thank you for highlighting that. But I dare ask very briefly, in terms of backlog of cases, we know this is a big issue in terms of dispensation of justice and the judiciary. Your quick reaction, because we have cases that are over 5 years old and are still ongoing in the justice system. What's your take on this, and perhaps also compare it to other countries, since you are by default from the ICJ as well?
You see, the backlog of cases is not an issue that you look at easily, because apart from the fact that we got a very low number of judicial officers to handle these cases, we have a problem in terms of how do you clear these cases. Do they go day to day, like the Chief Justice has just said? It has not happened. You can try to do that, but there are so many other reasons why cases can never go on day to day. And we hope that what they can do now is get enough judicial officers. There have been a proposal to engage more magistrates, engage more judges, so that all these issues can be handled as quickly as possible to ensure that justice is not delayed and then denied to the victims. But the process across the world, in some cases, the issue should not go beyond 6 months. And I hope that soon enough that we reach there. But the ratio of judicial officers vis-a-vis the population in Kenya is not commensurate to what we want to have. We should be looking at a determination where we have close to 2,000 to 3,000 magistrates to handle these cases. I'll give you an example in the UK, where we have the population in the UK. They have about 20,000 judges, and the population is slightly to triple of that of Kenya. And when you compare that and realize that we have about 600 magistrates in Kenya, it doesn't go commensurate to the kind of cases we have.
All right, Mugeni. Thank you for highlighting, especially what exactly is happening as well in the UK. Allow me to bring at this juncture Charles Kanjama, who's equally an advocate of the High Court. Charles, good evening. Thank you for making time. Let's get right into it. The judiciary has been blamed for slowing down the fight against corruption. They're also receiving criticism on how the scales of justice seem to be inclined towards, those with money getting swift justice or justice being dispensed to their advantage against those who are, not big fish, quote unquote. In your take, is there a sense of abuse in the legal process, and is the judiciary bold enough to deal with this?
Okay, so the first thing I would say is that there's always been this expectation that justice will be blind to economic status, to level of intelligence, social status, etc. And that's why you see even outside the Supreme Court building, there is a representation of blind justice in the form of a young child who's meant to be administering justice. The truth of the matter is that the reality on the ground, not just in Kenya, but in other countries, is that sometimes justice seems to favor the rich. The rich find it easier to raise the bond terms, to raise the funds that they need for security or for cash bail. The prisons are full of remandees who have been unable to raise figures as little as 10,000 or 20,000 shillings to come out on bail. It is a real tragedy. Something needs to be done in this particular area. So there is genuinely a concern by members of the public about justice being tilted towards the rich. And I think we need to find how the bail and bond policy can be refined so that it can take into account that those who are more impoverished are less likely to afford certain bond terms. But I think it is not fair to blame the judiciary for the current situation. The judiciary has been asking for finances, for more judges and magistrates to be appointed so that they can actually process the criminal cases in the courts much faster. And we've seen that there's a current standoff between the judiciary and the executive, the treasury saying that they don't have sufficient funds to release for new judges and magistrates. They are not appointing the 41 judges who were recently nominated by JSC. So that's not really something you can blame the judiciary on. My assessment is that each of us bears a part of the blame: the executive, the legislature, the judiciary, us lawyers, and even sometimes litigants who delay cases, witnesses fail to come to court when they are summoned, and so on. So we need a holistic solution where all the parties can play a role.
All right, Kanjama, speaking of a holistic solution, let me take you back to that issue of petty crimes and remand. I mean, is this logical, especially for non-repeat offenders being held in remand?
There are cases where it could be logical. Somebody could be a threat to themselves, domestic violence cases, somebody who's drunk silly and cannot be left out on their own. So I'll not say that there's an absolute bar against putting in remand petty offenders. But I would say that there should be a high bar that should be met by the judicial officer before taking to remand petty offenders, especially offenses which would not attract a penalty of more than 6 months. And that has been the practice that has been recommended, but sometimes it's not implemented in various magistrates' courts across the Republic.
All right, Kanjama, let me get your quick reaction. Yes, there are challenges, and yes, the image of the judiciary might be tainted. Real quick, what is the way forward despite these challenges? I mean, in the wake of the judiciary system being seen as favoring those who have, the means in terms of money, what is the solution in terms of these challenges?
I think the first solution is to assert the independence of the judiciary. Some of those who are attacking the judiciary on this issue are not friends of rapid justice and equality. They may be seeking to undermine the judiciary. So we must assert the independence of the judiciary. That's number one. Number two, we must encourage the judiciary to be more accountable by engaging them on issues like the bail bond policy. Partners should come together and see how can we work to ensure that justice is fair to both the poor and the rich.
All right.
And number three, for me, is very critical. The executive needs to appoint the 41 judges and allow the appointment of 100 to 200 new magistrates, so that when you have more magistrates, it's possible for cases to move faster and people not to spend long in remand. The DPP's office has to play its role to speed up prosecution, DCI to speed up investigations.
All right.
So you need a solution that involves very many stakeholders.
Okay, thank you so much, Charles Kanjama, for your input right there. Let's give Kelvin Mogeni a chance to also conclude. And, what's the way forward, according to you, despite these challenges? Really briefly, sir.
The very first thing that needs to be done is that Parliament should get on board and take ownership of the bail and bond bill that has been drafted. It has painstaking work that has gone on through the period so that we can have uniformity. The question about petty offenders, it's a constitutional issue. The police need to be, properly educated into that, and they can be able to be appraised that a person who's facing an offense where the penalty is less than 6 months or only a fine of money, that person should not be put in custody. And the DPP, together with other sector players, should, as quickly as possible, move to the relevant prisons and remand homes to ensure that the persons who are in custody, who are unable to raise bail, because of the poverty and other issues, should be given favorable terms because they are not a danger to the society. They have already been released on bail. The question is the terms. So that can be looked at and ensure that there is justice that can be played. As much as we look at the victims, we also look at the suspect because they are still innocent until proven guilty. I think that's a process that is allowed in the constitutional process. But at the end of the day, we should not blame any party here. The judiciary needs to be given capacity. They must be given enough funds. They must be given enough personnel. They must be ensured that they work in tandem with what is required in the international best practices. And with that, you can't just empower the police and the prosecutors and avoid to do the same to the judiciary. So the independence of the judiciary is not looked in a vacuum. It must be looked at in terms of what is given and what the output can be expected within the terms that are given.
All right, Kevin Mogeni, thank you so much for your input right here on The Big Story. He's an advocate of the High Court, the chair of ICJ Kenyan chapter, as well as a member of the Bail and Bond Terms Committee. We're also joined from our City Center studios by Charles Kanjama, who's an advocate of the High Court. Gentlemen, thank you so much for your time, as well as the DPP Nordin Haji for that conversation with our lead reporter, Sophia Wanuna. My name is Jesse Rogers. That's The Big Story. Keep it KTN News.